Trial procedures. Trial with assessor. 66. The court may at any time order a trial to be heard wholly or partially by the court sitting with an assessor, and the court may fix the remuneration for the assessor, and the remuneration forms part of the costs of the action. Trial of one question before others. 67. The court may order that one or more questions of fact or law arising in an action be tried and determined before the others. Trial by different modes of trial. 68. The court may order that different questions of fact arising in an action be tried by different modes of trial. Calculation of amount by officer of the court. 69. In an action in which it appears that the amount to be recovered is substantially a matter of calculation, the court may direct an inquiry, assessment or accounting under Rule 18-1. Use of recording device. 70. If authorized by the court to do so, a party may use a recording device to record evidence. Evidence of particular facts. 71. At or before a trial, the court may order that evidence of a fact or document may be presented at the trial in any manner, including a. By statement on oath of information and belief. b. By documents or entries in books. c. By copies of documents or entries in books, or d. By a specified publication that contains a statement of that fact. Order of speeches. 72. Addresses to the jury or the court must be as follows. A. The party on whom the onus of proof lies may open his or her case before giving evidence. B. At the close of the case of the party who began, the opposite party, if that party announces his or her intention to give evidence, may open his or her case. C. At the close of all of the evidence, the party who began may address the jury or the court, and the opposite party may then address the jury or the court, and the party who began may then reply, and the court may allow the opposite party to be heard in response to a point raised in the reply. D. If a defendant claims relief against another defendant, the defendant claiming relief may address the jury after the defendant against whom relief is claimed. E. If a party is represented by a lawyer, the rights conferred by this rule must be exercised by the party's lawyer. Court may make order respecting submissions. 73. At or before a trial, the court may make one or both of the following orders in respect of a party's submissions to the court at the trial. A. An order that all or any part of the submissions be in writing. B. An order that all or any part of the submissions be of limited length. Clerk to note time of trial. 74. On each day of a trial, the clerk must record the following. A. The time the trial begins and ends. B. The name of each witness. C. The time the witness evidence begins and ends. Failure to attend. Failure of all parties to appear at trial. 75. Without limiting any other power of the court under these Supreme Court civil rules, if no party is in attendance when the trial of an action is called, the action must be struck off the trial list unless the court otherwise orders. Failure of one party to appear at trial. 76. If a party is not in attendance when the trial of an action is called, the court may proceed with the trial, including hearing a counterclaim, in the absence of that party. Court may set aside judgment. 77. The court may set aside a verdict or judgment obtained if a party does not attend the trial. Rule 12-6, Jury Trials. Application of Rule 12-6. 0.1, Subrules 1 to 12 of this rule do not apply during the period starting on September 28, 2020 and ending on October 7, 2022. En. BC Reg 232/2020, SCH 1, BC Reg 53/2021, SCH S 1. Rules during specified period. 0.2. During the period referred to in Subrule 0.1. A trial must be heard by the court without a jury regardless of whether a party filed or served a notice, or paid any sum for the jury and the jury process, under this rule. B. The court may transfer a proceeding to the Provincial Court of British Columbia under Section 15 of the Supreme Court Act even though a party has filed a notice requiring a jury trial under this rule, and C. A party may not apply for an adjournment of a trial because the party may want to require that the trial be heard by the court with a jury, unless the court otherwise orders. En. Bc Reg 232/2020, SCH 1. Filing jury notice and paying jury fees before October 8, 2022. 0.3. Despite subrule 0.2, a party may require that the trial of an action be heard by the court with a jury by doing the following on or after March 29, 2021 for a trial scheduled to take place on or after October 8, 2022. A. Within 21 days after service of the notice of trial but at least 45 days before trial. I. Filing a notice in Form 47, and 2. Serving a copy of the filed notice on all parties of record. B. At least 45 days before trial, paying to the sheriff a sum sufficient to pay for the jury and the jury process. En. Bc Reg 53/2021, SCH S2. Application of Subrule 5 before October 8, 2022. 0.4. If a party files a notice under Subrule 0.3, a, the party on whom the notice has been served may, despite Subrule 0.1, make an application under Subrule 5 on or after March 29, 2021. En. Bc Reg 53/2021, SCH S2. Trial without jury generally. 1. Subject to Subrule 3, a trial must be heard by the court without a jury. Trial without jury in certain proceedings. 2. A trial must be heard by the court without a jury if the trial relates to a. The administration of the estate of a deceased person. B. The dissolution of a partnership or the taking of partnership or other accounts. C. The redemption or foreclosure of a mortgage. D. The sale and distribution of the proceeds of property subject to any lien or charge. E. The execution of trusts. F. The rectification, setting aside or cancellation of a deed or other written instrument. G. The specific performance of a contract. H. The partition or sale of real estate. I. The custody or guardianship of an infant or the care of an infant's estate, or J. A proceeding referred to in Rule 2-1(2). Notice requiring jury trial. 3. Subject to Rule 15-1(10), and Subrules 2 and 4 of this rule, a party may require that the trial of an action be heard by the court with a jury by doing the following. A. Within 21 days after service of the notice of trial but at least 45 days before trial. I. Filing a notice in Form 47, and 2. Serving a copy of the filed notice on all parties of record. B. At least 45 days before trial, paying to the sheriff a sum sufficient to pay for the jury and the jury process. Bc Regs 95/2011, SCH. A. S. 5, 65/2013, SCH. A. S. 2. Jury notice not to prevent transfer of proceeding. 4. The court may transfer a proceeding to the Provincial Court of British Columbia under Section 15 of the Supreme Court Act even though a party has filed a notice under Subrule 3. Court may refuse jury trial. 5. Except in cases of defamation, false imprisonment and malicious prosecution, a party on whom a notice under Subrule 3 has been served may apply. A. Within 7 days after service for an order that the trial or part of it be heard by the court without a jury on the ground that I. The issues require prolonged examination of documents or accounts or a scientific or local investigation that cannot be made conveniently with a jury. 2. The issues are of an intricate or complex character.
List this afternoon, Luke Evanshan.
Yes. Mr. Evanshan, you have a seat, sir. What I've done is I have some written reasons in this matter, and what I'm going to do is read a portion of my written reasons, commencing with just a brief summary of the position of the parties. This is how can I put this, probably the important part of the reasons and decision. And after I've done that, I'll provide a copy of the written reasons to each party. So commencing then with the position of the parties, the Crown, Ms. Selby MacDonald for the Crown submitted in essence that Crown had met the onus upon it and had proven all of counts 1 to 3 on the information before the court beyond a reasonable doubt. She did agree that as to count 1, the first head butt shown in the video evidence which occurred in the mall hallway outside the gym, but before the mall exit door, was a very small tap to Mr. Gamber's forehead and could therefore be de minimis or not an event that should ordinarily result in a criminal conviction. However, the second head butt, which occurred outside, was an intentional act on the part of the accused, was more forceful, and was hence an assault. As to count 3, the alleged threat uttered or conveyed by the accused to Mr. Gambier at the Steve Nash Gym, Crown submitted that the accused's initial conduct therein directed to Mr. Gambier amounted to a threat. In the training room after the accused had been asked to leave the gym a number of times while yelling or screaming liar 8 or 9 times, he turned and approached Mr. Gambier very closely, causing him to step back and put his hands up in a defensive posture. He felt threatened. As to count 2, the alleged assault of Constable McCarricher said to be in the cause of resisting his lawful arrest. Crown submitted that the accused knew Constable McCarricher, albeit in plain clothes, was a police officer. He was told he was under arrest and he strenuously resisted arrest. Further, the arrest without a warrant was lawful pursuant to Section 495 sub 1 sub A of the Criminal Code of Canada and the decision of Regina versus Story, 1991 SCR 241 at paragraph 17. In arresting the accused, Constable McCarricher was entitled to rely on a fellow officer's instructions as occurred here. Corey J., in delivering the decision of the Supreme Court of Canada in Story at paragraph 17, said this, 17. In summary, then, the criminal code requires that an arresting officer must subjectively have reasonable and probable grounds on which to base the arrest. Those grounds must, in addition, be justifiable from an objective point of view. That is to say, a reasonable person placed in the position of the officer must be able to conclude that there were indeed reasonable and probable grounds for the arrest. On the other hand, the police need not demonstrate anything more than reasonable and probable. Specifically, they are not required to establish a prima facie case for conviction before making the arrest. The defense. Some of the points made by the accused either do not relate to the charges he faces or support a defense, including my having a reasonable doubt that Crown had proven his guilt as to counts 1 to 3 to the above requisite standard. He did, however, argue that what he said to Mr. Gambier was not a threat. As well, his resisting arrest by Constable McCarricher was in his own defense of his loss of liberty. I took this to mean he was of the view that his arrest was unlawful and involved an excessive use of force. I note that the reason he said that he felt his arrest was unlawful was that a kinder, gentler way of detaining him, for example, a telephone call to his home inviting him to come to the detachment, could have been used, and if used, he would have attended. Mr. Gambier was not a credible witness. He targeted the accused in doing what he did to boost his ego, perhaps because he had a girlfriend and Mr. Gambier didn't. Finally, he said none of his actions amounted to an assault. Credibility. I turn now to a discussion of the relevant legal principles that apply to a trial judge's assessment of credibility of witnesses, all of which I have considered. One helpful decision on point is that of Regina and Perrant, 2000 BCPC 11, a decision of Her Honor Judge Roundthwaite, formerly of this court, wherein she dealt with the credibility of witnesses generally and how a trial judge can assess it at paragraphs 4 to 5 of her reasons, where she stated as follows. 4, in assessing credibility, courts have recognized a number of factors as helpful. 5, these include, number 1, the witness's ability to observe the events, record them in memory, recall, and describe them accurately. 2, the external consistency of the evidence. Is the testimony consistent with other independent evidence which is accepted? 3, its internal consistency. Does the witness's evidence change during direct examination and cross-examination? 4, the existence of prior inconsistent statements or previous occasions on which the witness has been untruthful. 5, the sense of the evidence. When weighed with common sense, does it seem impossible or unlikely? Or does it make sense? 6, motives to lie or mislead the court, bias, prejudice, or advantage. To consider the obvious possible motive of every accused person to avoid conviction would place an accused at an unfair disadvantage. As a result, I do not consider that possible motive when assessing an accused's testimony. 7, the attitude and demeanor of the witness. Are they evasive or forthcoming, belligerent, cooperative, defensive, or neutral? In assessing demeanor, a judge should not consider all possible explanations for the witness's attitude and be sensitive to individual and cultural factors which may affect demeanor. Because of the danger of misinterpreting demeanor, I would not rely on this factor alone. In paragraph 9 of her reasons, Her Honor Judge Roundthwaite used the term, quotes, ring of truth, quotes, as a different way of expressing the point in paragraph 5 above, namely, quotes, the sense of the witness's evidence, quotes. On this same point, our British Columbia Court of Appeal in Farnia v. Chorney, 1952, 2 DLR 354, commented, albeit in the context of credibility in civil actions, there is a lower and different burden of proof in such cases as compared to criminal cases. Nonetheless, Farnia is often referred to as containing a guiding principle for judges in assessing credibility in criminal cases. This well-known case from our Court of Appeal encourages trial judges not to rely too strongly on the demeanor of a witness or the fact that his or her evidence remains uncontradicted, but rather we should be concerned with whether the evidence of the witness is consistent with the probabilities affecting the case as a whole. The test, if you will, is repeated at page 4 of the Quick Law report of the reasons in this case as follows. 11, the credibility of interested witnesses, particularly in cases of conflict of evidence, cannot be gauged solely by the test of whether the personal demeanor of the particular witness carried conviction of the truth. The test must reasonably subject his story to an examination of its consistency with the probabilities that surround the currently existing conditions. In short, the real test of the truth of the story of a witness in such a case must be its harmony with the preponderance of the probabilities which a practical and informed person would readily recognize as reasonable in that place and in those conditions. Only thus can a court satisfactorily appraise the testimony of quick-minded, experienced, and confident witnesses, and of those shrewd persons adept in the half-lie and of long and successful experience in combining skillful exaggeration with partial suppression of the truth. Discussion. I will make, firstly, findings as to the credibility of the witnesses and then deal with each count in turn and whether or not it has been proven, in my view, by the Crown beyond a reasonable doubt. Mr. Gambier was a central witness in this case. I found him to be a credible witness. He seemed to have a good recollection of the events of the evening of July 25, 2017, and I felt he gave his evidence before me in a fair and objective way. For example, when questioned by the accused as to whether or not in making his decision to ask him to leave the gym and revoke his membership, had he not relied on a second-hand account that he could not be sure of, and answered yes. He readily agreed that he had first approached the accused in the change room based on what two other employees had told him, being in essence accurate. Mr. Gambier's testimony was corroborated by the video evidence presented by the Crown, in my view. He denied that he had headbutted the accused and at all times said he acted in self-defense. On viewing the video, he readily admitted that he had pushed the accused, but otherwise felt he had not, in following the accused out of the gym, acted at any time aggressively towards him. In my view, Mr. Gambier's testimony was not contradicted or shown to be unreliable in cross-examination. I also note that unlike the accused, for example, there is no evidence that on the evening in question he had been drinking or that his mental faculties were otherwise impaired. As well, I find that what he was doing throughout his dealings with the accused was wholly within his reasonable mandate as the gym manager dealing with a problem patron. I find the three police officers were credible witnesses as well, namely Constables McCarricher, McLean, and Sorg. They were not shaken in cross-examination. I did not consider Mr. Sampson to be a particularly significant witness in this case. Turning to the accused, unfortunately, I did not find him to be a credible witness. Very importantly, I find that he had a great deal to drink on the evening before any of the events referred to in counts 1 to 3 occurred. By his own evidence, he drank in 1.5 hours, very close to what he said was his usual beer consumption at the time in 1 week. And it was very strong ale as well, having he admitted an alcohol content of 7 to 7.2%, I assume alcohol by volume. I find that this alcohol consumption would have materially affected and did affect his mental processes, behavior, and conduct after 7:30 p.m. on July 25. I think this is very obvious, reflecting as I do on the multitude of biblical and unusual references he made during the evening, both to Mr. Gambier and the police. The majority of his conduct and utterances on the evening in question, in my view, clearly show that he was operating while his rational processes were materially impaired by the earlier consumption in quick succession of 6 strong ales. I found at times the accused at trial was either unresponsive to questions put to him or evasive in answering a question. For example, whether after drinking 6 ales did he feel the effects, to which he said no. Times his evidence made no sense and cannot withstand the test in the aforementioned Farina case. For example, his above answer that he didn't feel the effects of drinking 6 ales in 1.5 hours, yet described himself as a moderate drinker. A further example is his explanation as to why he turned his body to face Mr. Gambier on his way out, either that he feared he would be punched in the back of the head or in self-defense. This evidence makes little sense to me. Surely the accused well understood at the time that he was then an unwelcome patron of the gym and was being escorted outside, nothing more. There were a number of inconsistencies in Mr. Evanson's direct evidence and in his cross-examination, however not all on material points. One example in cross-examination was his denial he had headbutted Mr. Gambier in the mall, and later evidence that he didn't recall, he wasn't sure. A further example was Crown suggesting to him that he had not cross-examined Mr. Gambier on the suggestion that it was he, Gambier, as per the accused's own evidence, who had headbutted the accused, and he said variously that he had at least asked him about applying pressure on his face, but then said when asked again that he couldn't recall. Mr. Evanson again in cross-examination gave evidence suggesting he had at least on July 25 a bias towards the police. When asked why he had not remained at the gym to await the arrival of the police, if he felt in essence that it was he who had been assaulted, he said they would choose to victimize him had he spoken with them, but yet he denied that the impending arrival of the police at the scene had anything to do with his decision to leave the mall and take the bus home. In the result, I find that wherever the evidence given by the accused differs from that given by Mr. Gambier or the police officers, I prefer their evidence to that of the accused. I find that on his departure from the Steve Nash gym on the evening of July 25, when the accused throughout was, in my view, manifesting strong symptoms of being impaired by the alcohol he had just consumed, that he twice headbutted Mr. Gambier, on the second occasion more severely than on the first, which, if standing alone, would not in itself merit a criminal conviction. Thus, the Crown has proven he assaulted Mr. Gambier beyond a reasonable doubt. When Mr. Gambier pushed him away, he was clearly acting in his own self-defense. I find when Mr. Evanson twice headbutted Mr. Gambier, he was not acting in his own self-defense, and that Crown has proven this beyond a reasonable doubt. I find that the police attended at the Steve Nash gym and spoke to Mr. Gambier, who then gave them a statement and particulars of his assault by the accused, including confirming his name and identity to them. I find that Constable McCarricher learned in a police dispatch, and I understood as well from Constable Griffith, a fellow officer, and between 9:27 and 9:34 p.m., that Mr. Evanson had threatened and assaulted someone at the gym and was thus arrestable for these two charges. As a result, he attended on 17th Street essentially looking for him and located him thereon and eventually arrested him for these charges. I find that the test referred to in Regina and Story at paragraph 17 is met, and the arrest was lawful and made in accordance with section 495 sub 1 sub A of the Criminal Code of Canada. I find that the accused knew at all material times that Constable McCarricher was a police officer, and throughout the majority of Constable McCarricher's efforts to lawfully arrest him, the accused very actively resisted and assaulted McCarricher in the course of his performing his lawful duty. Finally, I find that while the accused's actions in the training area, when he was in essence being escorted out of the gym from the locker or change room, were somewhat menacing, they do not, in my view, amount to a criminal event within Section 264.1 of the Criminal Code of Canada. Section 264.1 states, everyone commits an offense who in any manner knowingly utters, conveys, or causes any person to receive a threat, A, to cause death or bodily harm to any person, B, to burn, destroy, or damage real or personal property, or C, to kill, poison, or injure an animal or bird that is the property of any person. The accused did not, according to the evidence, threaten to kill and cause the death of Mr. Gambier, notwithstanding his yelling or screaming, for the most part, that he was a liar, nor do I find that he conveyed in his actions towards Mr. Gambier a threat to do bodily harm to him. This term is also defined in the Criminal Code as follows, and I quote, bodily harm means any hurt or injury to a person that interferes with the health or comfort of the person and that is more than merely transient or trifling in nature. In reaching the above findings of fact and conclusions, I have kept in mind the provisions of the Regina versus WD decision referred to at the outset of these reasons with respect to each charge. As to counts 1 and 2, unless otherwise stated, I do not believe the accused. As well, I am not left with a reasonable doubt by the evidence of the accused or any evidence in this case as to his guilt on these two counts. On the basis of the evidence which I do accept as truthful, I am convinced beyond a reasonable doubt as to his guilt on counts 1 and 2. Thus, I find the accused guilty on counts 1 and 2. However, I dismiss count 3. I am going to place the original of these reasons on the court file. Madam Clerk, if you would take those and pass these, one to the Crown and one to the accused. You will each have an opportunity to review my summary of the evidence in this case and some introductory remarks that are not really that central to the decision that I have come to. And I think rather than adjourning now to permit you to do that, we should simply move forward if Crown is in a position to do that in light of my findings.
I can move forward to the next step, Your Honor, but just before we do that, I'm not sure, were counts 4 and 5 on information 64950-1, had Crown directed a state proceedings on those counts formally?
No, not yet.
I think it was intended that Crown
think
would ultimately do that. It was my understanding that, and Crown made this very clear, Ms. Selby McDonald, that Crown was proceeding only on counts 1 to 3.
Yes, so at this point, just to clean matters up, perhaps I'll direct a stay of proceedings then?
Yes.
On counts 4 and 5 on that information?
Yes, all right.
With respect to the 2 counts then on which Your Honor has found Mr. Evanshan guilty, Crown is seeking a pre-sentence report with a psychiatric component be
Yes.
prepared
All right.
to assist the court in sentencing.
Yeah.
That would be pursuant to section 721 sub 4 and 723 sub 3 of the criminal code.
Okay. All right, so the plan would be that I would order that pre-sentence report with that component, and
Character, or 3. The extra time and cost involved in requiring that the trial be heard by the court with a jury would be disproportionate to the amount involved in the action, or b. At any time for an order that the trial be heard by the court without a jury on the ground that the trial relates to a fast-track action or to one of the proceedings referred to in Subrule 2. No application for judgment necessary. 6. An application for judgment is not necessary unless an enactment or the Supreme Court civil rules otherwise provides. Judgment impossible on jury findings. 7. If, after any redirection the court considers appropriate, a jury answers some but not all of the questions directed to it, or if the answers are conflicting, so that judgment cannot be pronounced on the findings, the action must be retried. Only partial judgment possible on jury findings. 8. If the answers of the jury entitle either party to judgment in respect of some but not all of the claims for relief in the notice of civil claim, the court may pronounce judgment on those claims and the remaining claims must be retried. Jury failing to reach verdict. 9. If the jury fails to reach a verdict in accordance with the Jury Act, the action must be retried. Retrial. 10. A retrial under subrules 7 to 9 may take place at the same or subsequent sittings as the court may direct. Continuing trial without jury. 11. If, for any reason other than the misconduct of a party or the party's lawyer, a trial with a jury would be retried, the court, with the consent of the party who required a jury trial, may continue the trial without a jury. Trial may continue without jury. 12. If, by reason of the misconduct of a party or the party's lawyer, a trial with a jury would be retried, the court, with the consent of all parties adverse in interest to the party whose conduct, or whose lawyer's conduct, is complained of, may continue the trial without a jury. Part 13, Orders. Rule 13-1, Orders. Drawing and approving orders. 1. An order of the court. A. Subject to Subrule 15, may be drawn up by any party. B. Subject to Subrule 2, and paragraph C of this subrule, must, unless the court otherwise orders, be approved in writing by all parties of record or their lawyers. C. Need not be approved by a party who has not consented to it and who did not attend or was not represented at the trial or hearing following which the order was made, and D. After approval under this rule, must be left with a registrar to have the seal of the court affixed. When approval in writing not required. 2. If an order is signed or initialed by the presiding judge or master, that order need not be approved in writing by a lawyer or by a party. Form of order. 3. Unless these Supreme Court civil rules otherwise provide. A. An order made without a hearing and by consent must be in Form 34. B. An order made after a trial must be in Form 48, and C. Any other order must be in Form 35. Endorsement of order on application sufficient in certain cases. 4. If an order has been made substantially in the same terms as requested, and if the court endorses the notice of application, petition or other document to show that the order has been made or made with any variations or additional terms shown in the endorsement, it is not necessary to draw up the order, but the endorsed document must be filed. Order granted conditionally on document to be filed. 5. If an order may be entered on the filing of a document, the party seeking entry of the order must file the document when leaving the draft order with a registrar, and the registrar must examine the document and, if satisfied that it is sufficient, must enter the order accordingly. Waiver of order obtained on condition. 6. If a person who has obtained an order on condition does not comply with the condition, the person is deemed to have abandoned the order so far as it is beneficial to the person and, unless the court otherwise orders, any other person interested in the proceeding may take either the steps the order may warrant or the steps that might have been taken if the order had not been made. Order of judge or master. 7. An order of a single judge or master is an order of the court. Date of order. 8. An order A. must be dated as of the date on which it was pronounced or, if made by a registrar, as of the date on which it is signed by the registrar, and B. unless the court otherwise orders, takes effect on the day of its date. Approval of order. 9. An order may be approved by any judge. Requirement of consent order. 10. A consent order must not be entered unless the consent of each party of record affected by the order is signified as follows. A. If the party is represented by a lawyer, by the signature of the lawyer. B. If the party is not represented by a lawyer. I. By the oral consent of the party who attends before the court or a registrar, or 2. By the written consent of the party. Settlement of orders. 11. An order must be settled, when necessary, by a registrar, who may refer the draft to the judge or master who made the order. Appointment to settle. 12. A party may file an appointment in Form 49 to settle an order and must serve a copy of the filed appointment and a draft order on all parties whose approval of the order is required under Subrule 1, at least 1 day before the time fixed by the appointment. Party failing to attend on appointment to settle. 13. If a party fails to attend at the time appointed for the settlement of an order, a registrar may settle the order in the party's absence. Review of settlement. 14. The court may review and vary the order as settled. Registrar may draw order. 15. The court may direct a registrar to draw up and enter an order. Special directions for entry or service. 16. The court may give special directions respecting the entry or service of an order. Correction of orders. 17. The court may at any time correct a clerical mistake in an order or an error arising in an order from an accidental slip or omission, or may amend an order to provide for any matter that should have been but was not adjudicated on. Opinions, advice and directions of the court. 18. The opinion, advice or direction of the court must be entered in the same manner as an order of the court and is to be termed a judicial opinion, judicial advice, or judicial direction, as the case may require. Orders on terms and conditions. 19. When making an order under the Supreme Court's civil rules, the court may impose terms and conditions and give directions it considers will further the object of the Supreme Court's civil rules. Rule 13-2, Enforcement of Orders. Order to pay money to a person. 1. An order for the payment of money to a person may be enforced by writ of seizure and sale in Form 50. Order to pay money into court. 2. An order for the payment of money into court may be enforced by writ of sequestration in Form 51. Order for recovery or delivery of land. 3. An order for the recovery or the delivery of the possession of land may be enforced by writ of possession in Form 52. Order for recovery or delivery of property other than land. 4. An order for the recovery or the delivery of the possession of any property other than land or money may be enforced by writ of delivery in Form 53 or 54 or by writ of sequestration in Form 51. Appointment of receiver. 5. An order may be enforced by the appointment of a receiver under Rule 10-2. Execution by or against person not a party. 6. A person not a party to a proceeding, who obtains an order or in whose favor an order is made, may enforce the order in the same manner as if the person were a party to the proceeding, and an order that may be enforced against a person not a party to a proceeding may be enforced against that person as if he or she were a party to the proceeding. Remedy on non-compliance with mandatory order. 7. If a mandatory order or an order for the specific performance of a contract is not obeyed, the court, in addition to or instead of proceeding against the disobedient person for contempt, may direct that the act required to be done may be done so far as is practicable by the person who obtained the order, or by some other person appointed by the court, at the expense of the disobedient person, and on the act being done, the expenses incurred may be ascertained in such manner as the court may direct, and execution may issue for the amount so ascertained and costs. Issue of execution on conditional order. 8. If an order is to the effect that a person is entitled to relief subject to or on compliance with a condition or the happening of a contingency, the person so entitled, after compliance with the condition or the happening of the contingency, and after demand is made on the person against whom he or she is entitled to relief, may apply to the court for leave to issue execution. Order when right to relief has arisen. 9. The court, if satisfied that the right to relief referred to in Subrule 8 has arisen, may a. Order that execution issue, or b. Direct that any issue or question necessary for the determination of the rights of the persons be tried. Issue of execution on change of parties. 10. If a change has taken place, by death or otherwise, in the persons entitled or liable to execution, the person claiming to be entitled to execution may apply to the court for leave to issue execution, and the court may order a. That execution may issue, or b. That any issue or question necessary to determine the rights of the person be tried. Production of order before execution. 11. A writ of execution must not issue without the production to the registry of a copy of the order on which the writ is to issue. Endorsement of writ. 12. A writ of execution must be endorsed with the name and address of the lawyer or person causing it to be issued. Issue of writ of sequestration, possession or delivery. 13. A writ of sequestration, a writ of possession or a writ of delivery must not be issued unless there has been filed proof satisfactory to a registrar that a. In the case of an order, the order sought to be enforced I. Has been served on the person against whom the order is sought to be enforced, and 2. Has not been complied with, or b. In the case of a document, issued under an enactment, that on being filed in the court may be enforced as if it were an order of the court, the document I. Has been filed in the court. 2. Has, before or after being filed in the court, been served in accordance with the enactment or these Supreme Court civil rules on the person against whom the order is sought to be enforced, and 3. Has not been complied with. Issue of writ of execution if order to pay money within a period. 14. If the order sought to be enforced is for the payment of money within a specified period, a writ of execution must not be issued until the expiration of the period. Issue of writ of execution. 15. Subject to these Supreme Court civil rules or an order of the court, a writ of execution may be issued by a registrar at any time during the lifetime of the order sought to be enforced. When writ of execution is issued. 16. A writ of execution must be prepared by the person seeking to enforce the order or by the person's lawyer, must be sealed by a registrar and is, after that, deemed to be issued. Copy of writ of execution must be left with registry. 17. The person seeking to enforce the order or the person's lawyer, on presenting a writ of execution for sealing, must provide a copy of the writ of execution to the registry. Term of writ of execution. 18. A writ of execution, if unexecuted, remains in force for 1 year only, unless renewed. Renewal of writ of execution. 19. At any time before the expiration of a writ of execution, or a renewed writ of execution, the writ of execution may, on the application of the party issuing the writ of execution, be renewed for a 1-year period beginning on the date of the renewal. Hearing of writ of execution. 20. An application to renew a writ of execution may be heard by a. the court, or b. a registrar designated by the Chief Justice. Writ of execution to be endorsed. 21. A renewed writ of execution must be endorsed by the court or a registrar, with the date of the order granting renewal and the date of the renewal. Enforcement costs. 22. Unless the court otherwise orders, a party who is entitled to enforce an order is entitled to the costs, fees and expenses of enforcement including proceedings under the Court Order Enforcement Act, this rule and Rules 13-3 and 13-4. Registrar may fix amount. 23. Subject to Subrule 24 of this rule, if the Supreme Court civil rules provide or some other enactment provides that enforcement costs may be included in the amount endorsed on any writ of execution, a registrar may fix the amount to be endorsed on the writ of execution. Assessments and accounting. 24. If a judgment debtor alleges that he or she has satisfied an order for the payment of money or otherwise, whether or not the costs of enforcement and interest on those costs have been paid. A. Either the judgment creditor or the judgment debtor may apply to have the costs of enforcement assessed before a registrar, and Rule 14-1 applies, or B. The judgment debtor may apply to the registrar for an accounting. Registrar may certify on accounting. 25. On an accounting referred to in Subrule 24b of this rule, Rule 18-1 applies and a registrar may certify one or more of the following. A. The amount, if any, then due to the judgment creditor. B. The amount, if any, then due to the judgment debtor as a result of an overpayment. C. That the judgment has been paid. Certificate of same effect as order. 26. A certificate under Subrule 25c of this rule has the same effect as if it were an order under Subrule 30. Separate writs for costs. 27. On an order granting relief and costs, there may be, at the election of the person entitled, either one writ of execution or separate writs of execution for the relief granted and for the recovery of the costs. Judgment for recovery of property other than land. 28. If an order for the recovery of property other than land or money is to be enforced by writ of delivery, the court may, on the application of the judgment holder, A. Order that execution issue for the delivery of the property without giving the other party the option of retaining the property on paying the assessed value, and B. If the property cannot be found, and unless the court otherwise orders, order that the sheriff take possession of all the other party's lands, goods and chattels. I. Until the other party delivers the property, or 2. At the option of the judgment holder, until the sheriff realizes from the other party's goods and chattels the assessed value of the property. Acknowledgement of payment. 29. A debtor may require, as a condition of paying a money judgment, that the judgment creditor promptly execute, file and serve an acknowledgement of payment in Form 55. Order that judgment has been paid. 30. If a judgment debtor claims to have paid the judgment but has not obtained an acknowledgement of payment from the judgment creditor, the debtor may apply to the court for an order certifying that the judgment has been paid. Stay of execution. 31. The court may, at or after the time of making an order, A. Stay the execution of the order until such time as it thinks fit, or B. Provide that an order for the payment of money be payable by installments. Balance becomes payable if installment not paid when due. 32. Unless the court in an order under subrule 31(b) otherwise provides, if an installment is not paid by the time fixed for payment, the balance of the money remaining unpaid under the order is, at that time, due and payable without notice being given to the judgment debtor. Application for relief. 33. Without limiting subrule 31, a party against whom an order has been made may apply to the court for a stay of execution or other relief on grounds with respect to which the supporting facts arose too late for them to be pleaded, and the court may give relief it considers will further the object of these Supreme Court's civil rules. Application for directions. 34. A sheriff, judgment creditor or judgment debtor may apply to the court for directions under Rule 13-5 concerning the sale of any property taken in execution. Enforcement of certificate. 35. If a certificate under Rule 14-1, 27, or 18-1, 2, has been filed, it may be enforced as if it were an order of the court. En. Bc Reg 119/2010, SCH. A. S. 28. Rule 13-3, Subpoena to debtor. Subpoena to debtor. 1. A creditor who has obtained an order of the court for the recovery or payment of money or costs or both may issue out of the registry a subpoena in Form 56 on filing an affidavit showing that the order is not satisfied and that no writ of execution issued by the creditor is outstanding against the debtor. To whom subpoena must be directed. 2. A subpoena issued under subrule 1 must be directed. A. If the debtor is an individual, to the debtor. B. If the debtor is a corporation, to an officer or director of the debtor, or C. If the debtor is a partnership or firm, to a person liable to execution on an order against the debtor. Service of subpoena. 3. A subpoena issued under subrule 1 must be served at least 7 days before the date of the examination under subrule 4, and with the subpoena must be tendered any expenses the person served would be entitled to were he or she required to attend the court as a witness. Examination of debtor. 4. The examination referred to in a subpoena issued under subrule 1 must take place before an examiner and must be on oath as to the following matters. A. The income and property of the debtor. B. The debts owed to and by the debtor. C. The disposal the debtor has made of any property. D. The means the debtor has, or has had, or in future may have, of satisfying the order. Examiner. 5. The examiner must be A. The court. B. A master, or C. A registrar designated as an examiner by the Chief Justice. Examination. 6. At an examination under this rule, the creditor and the person subpoenaed may, with leave of the examiner, call witnesses who may be cross-examined. Adjournment. 7. The examiner may adjourn an examination under this rule from time to time. Debtor refusing to attend or respond. 8. If the person subpoenaed under subrule 1 A. Does not attend as required at the examination under subrule 4, or an adjournment of it. B. Refuses to be sworn or to affirm, or to answer one or more of the questions put to the person. C. After an order to that effect, refuses or neglects to produce or permit to be inspected any document or property, or D. Does not give answers that are to the satisfaction of the examiner. Then E. If the examiner is a master or registrar. I. In the case of default under paragraph A, the examiner must make a report in Form 57 and fix a time and place at which the creditor may attend before the court, and at that time and place the court may, at the request of the creditor and without notice to the person subpoenaed, order A. Committal, or B. Apprehension under Rule 22-8, 5, and 2. In the case of default under paragraph B, C, or D, of this subrule, the examiner must make a report in Form 57 and fix a time and place for the person subpoenaed to attend before the court, and at that time and place the court may, at the request of the creditor and without further notice to the person subpoenaed, order a. Committal, or b. Apprehension under Rule 22-8, 5, or f. If the examiner is the court, the examiner may order committal. Creditor failing to attend, etc. 9. If the creditor who issued a subpoena under Subrule 1 fails to attend at the examination under Subrule 4, or if the examiner is of the opinion that the proceedings are unnecessary or vexatious, the examiner may order the creditor to pay to the person subpoenaed a sum of money by way of compensation and may order that sum to be paid promptly or to be set off against the debt. Debtor unreasonably refusing to pay. 10. If it appears to the examiner that a. The debtor has, with intent to defraud the creditor, made or caused to be made any gift, delivery or transfer of property, or has removed or concealed property. b. The debtor has unreasonably neglected or refused to pay the debt in whole or in part or to pay any installment ordered to be paid, or c. The debtor is a corporation and the person subpoenaed has done, authorized, permitted or acquiesced in an act or omission described in paragraph A or B. Then d. If the examiner is a master or registrar, he or she may make a report of his or her findings and fix a time and place for the person subpoenaed to attend before the court, and at that time and place the creditor may apply without notice for committal, or e. If the examiner is the court, the examiner may order committal. Order for payment. 11. At an examination under this rule, the examiner may make one or more of the following orders. A. For the payment of the debt by installments. B. For the payment of the debt on or before a fixed date. C. Varying or rescinding any previous order. D. For payment to be made to a registrar, to the creditor or to the creditor's lawyer. E. Fixing the costs payable by the debtor without assessment. And if the examiner is a master or registrar, the order has the effect of an order made by the court and must be entered accordingly. Notice of application for committal. 12. If a debtor fails to pay in accordance with an order made under Subrule 11 by an examiner, the creditor may file a notice of application for committal in Form 58 on filing an affidavit showing that the default has occurred, and Subrules 2 and 3 apply. Order for committal. 13. The court may order committal of a debtor if satisfied that a. The order to pay has not been obeyed. B. The person knew of the order, and c. The person has not shown good cause why an order of committal should not be made against him or her. Costs payable by debtor. 14. The court may fix the costs payable by the debtor without assessment. Form of order. 15. An order of committal must be in Form 59 and must commit the person named in it to prison for a term not exceeding 40 days. Term of order. 16. An order of committal must not be enforced after the expiration of 1 year after the date the order was made. Payment to sheriff. 17. A creditor seeking to enforce an order of committal must pay to the sheriff for the maintenance of the person committed the sum of $10 per day for each day of imprisonment by weekly payments of $70 in advance. Maintenance money recoverable. 18. The maintenance money paid by a creditor under Subrule 17 is a disbursement recoverable by the creditor from the debtor as costs of execution, without order. Debtor to be brought before court. 19. Subject to Subrule 21, a sheriff or peace officer executing an order of committal must promptly bring the person arrested before the court, and the person arrested may be examined by the court, and if the court considers that imprisonment is not appropriate, the court may stay execution of the order of committal and, in that event, must a. Fix a time and place for a hearing to determine whether or not the order of committal should be set aside or varied, and b. Give directions for notice of that hearing to be given to the creditor. Application to set aside or vary order. 20. A person who is the subject of an order of committal may apply to the court to set aside or vary the order, and the court may order a stay of execution of the order pending the hearing of the application and give directions for service of notice of the hearing. Payment of debt. 21. A person who is the subject of an order of committal may pay the amount payable endorsed on the order either to a registrar or to the sheriff, peace officer or warden in whose custody he or she is. Receipt for payment. 22. On payment under Subrule 21, to a registrar of the amount payable, the registrar must issue a receipt to that effect. Release from custody. 23. On payment under Subrule 21, to any of them of the amount payable or on being shown a registrar's receipt to that effect, a sheriff, peace officer or warden must release the person committed from custody and must endorse the order accordingly and return it to the registry. Payment to creditor. 24. All money received under this rule must be paid promptly to the creditor. Requisition for discharge. 25. A creditor who has obtained an order of committal may file in the registry a requisition in Form 17 requesting discharge of the person committed, and a registrar must endorse the requisition and a copy with the words, "This is your authority to discharge, name." From custody above the registrar's signature, and, on being shown the copy of the requisition, a sheriff, peace officer or warden must release the person committed from custody and must endorse the order accordingly and return it to the registry. Failure to pay sheriff. 26. A sheriff who has not received maintenance money as provided in Subrule 17, must a. If the person committed is in the sheriff's custody, release the person committed, or b. If the person committed is in the warden's custody, must notify the warden, who must release the person committed. And each must endorse the order accordingly and return it to the registry. Liability imposed by order. 27. Imprisonment under the Supreme Court's civil rules does not extinguish the liability imposed by an order. Repealed. 28. Repealed. BC Reg 119 2010, SCH. A. S. 29. Rule 13-4, Examinations in aid of execution. Definitions. 1. In this rule, judgment creditor means a person entitled to enforce an order of the court, whether for payment of money or otherwise. Judgment debtor means a person against whom the order may be enforced. Examination of judgment debtor. 2. If a judgment creditor is entitled to issue execution on or otherwise enforce an order of the court, the judgment creditor may examine the judgment debtor for discovery as to a. Any matter pertinent to the enforcement of the order. b. The reason for non-payment or non-performance of the order. c. The income and property of the judgment debtor. d. The debts owed to and by the judgment debtor. e. The disposal the judgment debtor has made of any property either before or after the making of the order. f. The means the judgment debtor has, had or may have of satisfying the order, and g. Whether the judgment debtor intends to obey the order or has any reason for not doing so. Examination of corporate, partnership or firm judgment debtor. 3. An officer or director of a corporate judgment debtor, or a person liable to execution on the order in the case of a partnership or firm judgment debtor, may, without an order, be examined for discovery on the matters set out in Subrule 2. Limitation. 4. Unless the court otherwise orders, a person examined under Subrule 2, or 3, must not be further examined in the same proceeding for a year. Examination of person other than judgment debtor. 5. On being satisfied that any other person may have knowledge of the matters set out in Subrule 2, the court may order that other person to be examined for discovery concerning the person's knowledge. BC Reg 119 2010, SCH. A. S. 30. Order in certain cases. 6. If a difficulty arises in or about the execution or enforcement of an order, the court may make any order for the attendance and examination of a party or person it considers will further the object of these Supreme Court civil rules. Application of examination for discovery rules. 7. Rule 7-2, 4, 5, 11, 12, 14, 17, 18, 22, 28 applies to an examination under this rule. Bc Reg 95 2011 SCH. A. S. 6. A. Dot. Use of examination. 8. Any part of an examination for discovery under this rule may be given in evidence in the same or any subsequent proceeding between the parties to the proceeding or between the judgment creditor and the person examined for discovery. Costs. 9. Unless the court otherwise orders, the party conducting an examination under this rule is entitled to recover the costs of the examination from the judgment debtor. Service of notice. 10. Before conducting an examination for discovery under this rule, the party wishing to conduct that examination must do. Part 17. Requisition proceedings. Rule 17-1, Requisitions. Proceedings to which this rule applies. 1. A proceeding referred to in Rule 2-1, 2, may be brought under this rule if a. All persons affected by the orders sought within the proceeding consent, or b. The proceeding is one of which notice need not be given. Filings required. 2. A proceeding referred to in Sub-Rule 1 may be brought by filing a. A requisition in Form 31. b. A draft of the proposed order. I. If the order is by consent, in Form 34, or 2. In any other case, in Form 35. c. In the case of a proceeding referred to in Sub-Rule 1, a. I. Evidence that the order sought is consented to, and 2. Any consent or comments of the public guardian and trustee required under Section 40 of the Infants Act, and d. In the case of a proceeding referred to in Sub-Rule 1, b. Evidence in support of the order sought.